Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. I will dictate a full passage, so take frequent break. The appellants as plaintiffs instituted suit in the court of small causes Allahabad against Mishri Lal, the predecessor in interest of the present respondents seeking his eviction from the suit premises on the ground of default in payment of rent and subletting of the suit premises without the knowledge and approval of the landlords, that is, the appellants. The appellants claimed themselves to be the joint owners of the suit premises since the death of their grandmother Chameli Devi. The original defendant tenant in his written statement though admitted the tenancy under Shrimati Chameli Devi, the grandmother of the appellants. He refused to acknowledge the appellants as his landlords. He claimed that the tenancy had commenced from 1957 and that he had paid rent up to the month of September 1989 to the landlord Bholanath, father of the appellants, and that on his refusal to accept the same thereafter he had deposited the rent in court under Section 30 of the Act. The defendant tenant admitted Srimati Chameli Devi to be the landlady who used to realize the rent till her lifetime, and after her death Bholanath, her eldest son, used to collect the same. He admitted the receipt of the notice dated 18/8/1989 but denied that he was a defaulter in payment of rent or that he was liable for eviction from the suit premises. Parallelly, the appellants also filed an application under Section 21 of the Act before the prescribed authority against the original defendant tenant seeking release of the suit premises on the ground of bona fide and genuine need therefore to, amongst others, conduct their business therein. This application was contested as well by the original defendant by filing his objection questioning the bona fide need of the appellants. The trial court decreed the suit both on the ground of default in payment of rent and subletting of the suit premises. In reaching this conclusion, it, amongst others, took note of the testimony of Bholanath, son of Shrimati Chameli Devi, who supported the pleaded case of the appellants and endorsed the factum of execution of will by Shrimati Chameli Devi, on the basis of which the appellants claimed joint ownership of the suit premises. While upholding the allegation of subletting, the trial court as well held that the deposit of rent made by the original defendant was not in terms of the Act and therefore he was not entitled to the protection from eviction. This verdict was challenged by the original defendant tenant in revision before the District Judge Allahabad, who reversed the same on the ground that the appellants have not been able to prove that they were the exclusive landlords owners of the suit premises. The appellants thereafter filed a writ petition before the High Court. By the impugned judgment and order as well, the High Court, while limiting itself to the aspect of the proof of the will, concurred with the revisional court and dismissed the suit of the appellants. Apropos the proceedings based on the application under Section 21 of the Act for the eviction of the original defendant on the ground of bona fide requirement, the High Court by the impugned verdict upheld the rejection thereof as recorded by the prescribed authority by negating their status of that a landlord. The competing assertions and the materials on record have been duly taken note of. Before adverting thereto, it would be appropriate to take a brief survey of the relevant provisions of the Act, which, as the title suggests, is a legislation for regulation of letting and rent of and the eviction of tenants from certain classes of building situated in the urban areas and for matters connected therewith, the original defendant having accepted Srimati Chameli Devi as his landlady and thereafter continued to pay rent to her son Bholanath, the father of the appellants, in terms of the definition of landlord in section 3 within bracket J of the Act, he during his lifetime and after his demise the respondents are stopped under section 116 of the Evidence Indian Evidence Act 1872 to dispute the status of the appellants as their landlord in a suit for his eviction from the tenanted premises, that a tenant during the continuance of the tenancy is debarred on the doctrine of estoppel from denying the title of his landlord through whom he claims tenancy, as is enshrined in Section 116 of the Indian Evidence Act 1872, is so well settled a legal postulation that no decision need be cited to further consolidate the same. To reiterate, the High Court, by the decisions impugned, had dismissed the suit and the application for release of the suit premises under Section 21 of the Act principally on the ground of want of standing of the appellants. In the face of the determination made herein above, the said conclusion is unsustainable on facts and in law, and are thus liable to be set aside, which we hereby do, having regard to the conclusions recorded on the aspect of default in payment of rent and subletting, both statutorily recognized grounds for eviction of a tenant under Section 20 of the Act, it is considered inessential to dilate on the ground of bona fide requirement and comparative hardship. In the wake up of the above, the impugned judgments and orders of the High Court are set aside and the suit of the appellants is decreed in full. The respondents would vacate the suit premises at the earliest and in no case later than 3 months from today. The appeals are allowed. No cause.